Hello and welcome to our conversation today called You Decide Who Decides, Making an Enduring Power of Attorney for Financial Decisions. My name is Brett Osmond and I'm the editor of Compass, and I'm coming to you today from Gadigal land, part of the Eora Nation, and I welcome elders past and present to today's conversation and to all of you. In fact, we're going to have a brilliant conversation with Liz Samra from the ACT Human Rights Commission. Welcome, Liz.
Thanks, Brett. Glad to be here.
Now, as everybody is joining the conversation, I've just got a little bit of housekeeping. We're going to have the questions facilitated through the chat. So hopefully all of you have access to the chat. I've activated it for everybody. Type your questions in there and we will get back to you. That's today's focus, answering your questions. We're also going to be talking about lots of different aspects of an enduring power of attorney and what it means for people in the ACT, and also contextually, what do enduring powers of attorney look like in other parts of the country? How do you make one? Where do you register it if you have to? Who decides if you've lost capacity? Who is the best candidate to be an attorney? And so much more. So I'm going to jump in straight away and ask a question to you, Liz. What is an
Sure.
enduring power of attorney for financial decisions?
Thanks, Brett. An enduring power of attorney is a legal document which gives where a person in the ACT, we call them a principal, can give one or more people called attorneys the power to make decisions for them in relation to their financial affairs. In the ACT, we've got the one document that's used for multiple different decisions, and other jurisdictions might have different documents for financial matters, for personal care matters. In the ACT, it's the one document that a person makes, so they can nominate which matters they want to give an attorney power to make decisions for when they lose capacity.
One of the,
Yeah.
I think, important things to acknowledge, and I'm sure some of the people joining our conversation today will know this, but an enduring power of attorney is a different legal document in different states and territories around Australia. In the Northern Territory, it's called an advanced personal plan, and you don't appoint attorneys, you appoint decision makers. And as you've highlighted, in some states, it takes in both financial and lifestyle matters. But today we'll try and just focus on financial decisions. So in the ACT, how do you go about making an enduring power of attorney? What are your options?
Well, anyone over 18 can make an enduring power of attorney if they have the decision-making ability to make an enduring power of attorney. There's a prescribed form used. So in the ACT, we have a law that sets rules around making enduring power of attorneys, and part of that is a form that needs to be filled out with certain requirements that meet that threshold. So an attorney has to be over 18, a principal has to be over 18 and have decision-making ability and enter into the document freely and voluntarily, so not be coerced into appointing one or more people.
Now that
Now you can
form,
go, yep.
no,
Sorry, Brett.
yeah, and I was just going to say that form you're talking about
Uh-huh.
is available on the Compass website. So that's compass.info. Compass has a section on enduring powers of attorney, and within that you can click on the ACT section and find those forms. Yeah. Do you have to register an enduring power of attorney in the ACT?
In the ACT, you only have to register an enduring power of attorney if you are going to deal with real property. And so, for example, if the principal gives an attorney the power to sell their home, residential home, for example, that attorney would need to register the enduring power of attorney or power of attorney with the ACT Land Titles Office.
Right.
So that would be the requirement.
Now,
otherwise, I think in Tasmania, is that right, Brett? There's a requirement to register enduring powers of attorney, but in the ACT, apart from that, we really don't have any other requirement.
Yeah, it appears that the Tasmania is the only state that requires you to register your enduring power of attorney regardless. But I think in every state and territory, if you're going to transact real estate, then you have to have it registered with the relevant land titles office. Now, for a document like this, it potentially could be around for a very long time. And so it's quite feasible, and probably more often than not, an enduring power of attorney would require an attorney at some stage to sell real estate, potentially to fund care. And so it is something that I wasn't aware of, that you needed to transact. What happens if you, as an attorney, need to sell real estate, but it hasn't been registered at a land titles office? Is there a remedy for that situation?
I think if the current document's still valid and on foot, it would just require registration before doing that, is my understanding.
Right. Even if the principal had lost capacity.
So if the principal's, look, I'm not quite sure, but I would say if the principal, if it's a legal document and it's been validly, executed and done in a manner which is consistent with the law,
You could just register it.
it would require registration. So I think if the principal did it at a time where they had the capacity to do it and all of that was above law, then it could be registered, is my understanding.
Now, don't hesitate to ask us a question. I've got a few here to put to Liz, but by all means, use the chat to give us some questions. I think there is a hand up. I will just have a look. Linda has her hand up. I hope that everyone is able to use the chat. If the chat is not active, please don't hesitate to jump into the Q&A, just so that you have another option there. Now, I wanted to ask you, what are the benefits, sort of the core benefits of having an enduring power of attorney?
Thanks, Brett. And that's a really important question. So the key point of an enduring power of attorney is an enduring one is that it lasts after the principal can't make decisions for themselves anymore. So they lose the decision-making ability to make decisions around their, say, finances, their personal matters, their healthcare matters. So we can't predict what's going to happen to us in the future, right? We could get knocked over by a car, have a stroke, develop a cognitive impairment, which impacts our ability to make decisions. So it's a really good tool that we can utilise to plan ahead in the event that we've got an idea of how we want to continue to live our lives if we don't have that ability anymore, and who we think would be best placed to make those decisions for us, and in particular in a way that is going to reflect to the best extent possible how we would want to live. So give effect to our will and preference, our wishes, if we no longer can continue making those decisions for ourselves into the future.
Yeah, so it's really about having control, isn't it? About the decisions that you want made on your behalf at some stage in the future, or made in a supportive decision-making situation. So what happens, we're getting some questions, I'll jump to those in a moment. What happens though if you don't have an enduring power of attorney in place in the ACT? And you lose the ability to make decisions for yourself, financial decisions?
Yeah, so look, if you haven't made an enduring power of attorney, when you can, when you're able to, and then you lose that ability to make an enduring power of attorney because you can't meet that threshold requirement of understanding the nature and effect of entering into an enduring power of attorney. The option would be for the matter to go to the ACT Civil and Administrative Tribunal here in the ACT, the ACAT, to determine whether or not a financial manager for the purposes of financial property related matters needs to be made. So it will really depend on whether there is a need for those decisions. And if so, and there is impaired decision-making ability, then the tribunal would be likely to appoint a substitute decision maker through that process.
Yep. Now we've got a question here from Damien. Can my sister sign on to our father's enduring power of attorney from New Zealand?
There are, an attorney can, so in the ACT, if the person's in the ACT, the principal can, as far as I'm aware, needs to be witnessed and by two witnesses. One's an authorised witness, so someone that is authorised to sign statutory declarations, and the other is another witness. So there needs to be two witnesses signing the document while the principal signs, and then an attorney can sign separately.
Right. So yes, I think, Damien, it is possible. Your father would have to have capacity. However, you can't make changes, can you, to an EPOA once the principal has lost capacity?
No, absolutely. So a person, if they wish to change their existing enduring power of attorney, they can make a new power of attorney while they have decision-making ability to do so. You cannot make an enduring power of attorney or amend if you have lost decision-making ability.
Yeah. So
or revoke one, indeed.
Yeah. So I'm going to talk about revoking in just a moment. Catherine asks, can you have an enduring power of attorney but not have it activated until there is an impairment?
Absolutely. So in the ACT, we've got the one document where, as I indicated, you can give parties multiple, an attorney choice to have decisions over, healthcare, personal care, medical research, and finance, property matters. Now, in fact, in the ACT, the only way an attorney can make decisions for you is in the financial realm immediately. All other decisions can only come in, that power can only kick in once the principal loses decision-making ability. So if you want your attorney to only be able to make decisions about your finances on a particular event, you can tick that. Or you can also indicate in the form that you want them to make a decision for you when you lose capacity and not before that. Yeah. So there's the option of ticking immediately or on loss of capacity or at another time.
Great. Now keep the questions coming. Amber has asked a very good follow-up question there. I mean, when we're talking about enduring powers of attorney, we're often talking about capacity. When we're going to lose capacity, if we have capacity. And capacity is essentially the ability to make a decision, isn't it? So you need to be able to understand the decision that's being put before you, to weigh up alternatives to that, and be able to communicate an answer, and it doesn't have to be verbal. But who decides if you have or you don't have capacity at CT?
It's a legal question, Brett, ultimately, whether or not a person has decision-making capacity. So if it's contested, the tribunal here in the ACT, the ACAT, can make a determination on whether or not a person has impaired decision-making ability. But ultimately, I think for the purposes of having an enduring power of attorney kick in, like enacted, if you want to use that word, people would often seek an opinion from a medical practitioner to ascertain whether or not they have decision-making ability in relation to particular issues. So, and then that is very much decision specific. specific as well. So whether or not this person can make decisions about their financial affairs or their personal affairs, healthcare matters, medical research
Yeah.
matters.
Now, Amber, you've asked a very good question. We're going to follow it up in a moment and talk about supported decision making because capacity, and we've got a great article on Compass, compass.info, in our Enduring Powers of Attorney section called Having Capacity. I do encourage you to read it. There's a great short video there as well, because capacity is not a black and white thing. As you've just inferred, you can have the capacity to decide what you want for breakfast, what you want to wear for the day, a number of decisions, but you may not be able to make complicated financial decisions. And also, capacity is something that can be supported. So we'll talk about supported decision making in a moment when we come back to it. But it's a great article, and I highly recommend it to you. Now, I've got an article from Dayani. What can be done if an enduring power of attorney is not, or an attorney, I should say, is not acting in the best interests of the principal?
Yeah, thanks for that important question. And this might be a plug for the Human Rights Commission here in the ACT, because in the ACT there are multiple options available to people if they feel that their attorney is acting, is breaching their obligations as an attorney. So if there are concerns, particularly if the principal has lost decision-making ability, or if they're vulnerable more broadly, they can make a complaint to us, and we meet with the principal, so meet with the person to get a sense of what's going on for them, and then we can try and investigate the situation. So that's one absolutely available pathway to people. And it's one where we take a conciliation approach, so a dispute resolution focus in particular, because often they're families that are involved, and the maintenance and preservation of relationships is really important to people. So that's one option. If the person has decision-making ability and they think that the attorney's misusing their power or is not following their wishes or is overriding their wishes, they can revoke it themselves. If they have lost the decision-making ability and there are real concerns, the other option is for someone to make an application to the ACAT for a review of their review of the attorney's decision-making.
Okay.
I think there's a distinction as well about best interests and wishes that I think is important to raise, because what we often see is that an attorney may not necessarily think that they're, might be wanting to make decisions which in their view is in the best interests of the principal, but in fact it may not at all be consistent with the principal's view and preference and the way they've lived historically. So you need to unpack what's actually going on in every situation. And there are different, if there's a clear conflict transaction, or where if the attorney, for example, is taking money from the principal, the mum's account, and spending it on themselves, then clearly that's a breach of their obligation. So you really need to identify what the issue is and work from there. But there are certainly options to protect people.
Great. Thank you, Liz, for that. Now, Damien asks, sorry, I should say Janina asks, we'll come to Damien in a moment. Janina asks, who registers the enduring power of attorney with the Land Titles Office? Can it be your lawyer, or do you do it yourself?
Look, I don't know that. I'd suspect it could be your lawyer, it could be the principal if the attorney's doing it. Probably.
Okay.
Land titles would know, but I think if the principal's got capacity, you would expect it would be the principal at that point,
Yes.
Or their solicitor that would lodge it.
Yes. Now, Damien asks, that's what I want. I don't want to be the only one on the EPA. Witnesses aren't a problem. Okay, great. I'm pleased we're able to answer that question for you, Damien. I'm going to just jump into asking you about attorneys. Obviously, that's a very important role. Choosing the right person to be your attorney on enduring power of attorney is giving a lot of power potentially to that individual. How many attorneys can you have in the ACT? Is it just a role for one person, or can you have multiple attorneys?
Yeah, the law in the ACT allows for one or more attorneys, and you can tailor the document as you wish. So you
Yep.
can appoint one attorney to make decisions about your finances, one or more attorneys. You could have a different attorney to make decisions about your personal care or healthcare matters. So
Right.
it really depends on, I guess, what you want to do and who you think you can trust and who you think might be best suited for the particular decisions at hand. You might
Great.
have a family member or whoever that you want to appoint that might not be really good with money, or
Yep.
might have a history of addiction or gambling that might adversely impact their ability to
Yeah.
manage
Yeah.
finances in a way. So you might not want to appoint them, but they might be really good at healthcare. So you
Right.
can really kind of create the framework and for future
That
planning
works
as
best for
you
you.
wish.
Yeah.
Yeah.
So when you have multiple attorneys, can you create it in such a way that they have to agree?
Absolutely. So
I
yeah,
guess is making decisions jointly, or
yeah,
can they make decisions separately?
yeah.
Separately. Yeah.
Yeah. So the legislation allows for people to be able to make decisions together and separately. So you can specify whether you want a couple of attorneys to together make the decision to sell your house or
Yep.
do your banking, and then separately for certain matters. So you really need to give, and it's probably, I would recommend that people get legal advice if they can afford it,
Yep.
because it is, you are giving people a whole lot of power to make decisions about yourself and your assets in the future. So it would be good to get that independent legal advice, but you certainly can tailor that. But you also need to think about the implications. If
Yep.
you are going to have two people make a decision jointly, because you need to think about whether or not there are going to be problems with them getting on, whether
Yep.
they live in the same city, is there going to be
Yes.
impediments to them making those decisions? And so they're
Yeah.
things you really need to think about
Yeah.
at the time that you create the document.
Now, I'm just going to interject here and just let everybody know the meaning behind today's title, You Decide Who Decides, where a number of the answers to these questions you'll be able to find. You Decide Who Decides is a fantastic guide that is available on the Compass website, compass.info. There's a big banner on the homepage that you can click and it will take you there. It has been just updated and published by the Australian Guardianship and Administrative Council, and it is specifically about making an enduring power of attorney for financial decisions. So it has lots of answers to some of these questions that we've been talking about, including who makes a good attorney. We've got a question here from Linda. Can I nominate my husband if he has capacity at that point, and I do not? Well, firstly, you have to nominate your attorneys and have this document in place before you lose capacity. And there should be no hindrance, is there, to choosing your partner, your husband, your adult children, a close friend. You really have, basically, you can choose anyone as long as they're over 18 and have
And then
capacity
they
themselves.
themselves don't. And yeah,
Yeah.
exactly.
Yeah.
And I think it's important to really, when deciding who to choose, you need to think about who you trust, whether or not you think a person is going to be able and capable of
Yes.
carrying out the function that you've given them the power. Whether, for example, they are a good advocate. Do you think they'll be able to advocate on your behalf if necessary, make calls, advocate in a health setting, in financial settings, be
Yes.
comfortable speaking to lawyers and banks, whether they're financially astute, if you've got a complicated financial arrangement that needs to be managed, if you've got multiple people, whether or not they get on, whether
Yeah.
you trust, importantly, that they will respect your choices and give
Yeah.
effect to your wishes, I think is a big one. So
Yeah.
someone that you know that is going to respect how you live and what you want in the future.
Yeah. Yeah. That's a big one,
People-
isn't it? Because they're not making decisions based on what they think is the right thing to do. It's what they think you want, and what you would choose. So
Yeah.
it's a really important distinction. One thing I did want to just add, Linda, is that I myself am approaching 60, so I've got an enduring power of attorney in place, and I've nominated my partner. And then beyond that, I have substitute attorneys. And one of them is a niece who is much younger than me, because this document can last for a very long time. And if we choose people who are the same age as us, then we potentially could run the risk of them losing capacity in much the same way we ourselves might. So, do you think it is a good idea to have a substitute decision maker who is significantly younger than you and fits all of the other criteria that we've been talking about?
Is that for me to
Yes,
answer?
yes.
Look,
Sorry, Liz.
I think
Yeah.
it really depends, Brett. Like
Yeah.
people could be 80 and be great at making
Yeah.
decisions. So I think, I think the more important point is to potentially review
Right.
your attorney, maybe every couple of years. You don't have to change it, but just review the situation to see
Yeah.
whether or not the people that you've appointed are still appropriate. People that are younger than you could be great at making decisions, older than you. I
Yeah.
think it really depends on
Really
the
depends.
circumstances.
Now, if you
That's
do want to make a change, you really have the way to do that is you have to revoke it, don't you? And how do people go about revoking an enduring power of attorney in the ACT?
Yeah, so there's a document as well that you could use to revoke your enduring power of attorney. And it's important to inform the attorneys and anyone else that has a copy, like banks or whatever,
Yeah.
health institutions, because it's the
That you've
one
got a new
document.
one.
You've
Yeah.
got a new one, or you can just make an enduring power of attorney and indicate that all previous attorneys have been revoked.
Right, right. Great. We've got a
Powers of
question
attorney.
here. Yeah, we've got a question here from Amber again. What if a geriatrician says you don't have capacity, but the assessments were done when the person was unwell?
Yeah, well, capacity can fluctuate.
Yeah.
Is this if it's in the context of appointing someone or multiple people to be your attorney? So if it's a point of making an enduring power of attorney, then that might be, evidence that they do lack decision-making ability at that time. But people depends on what's going on for the person, but
Yeah.
they might improve. They might have had a urinary tract infection and were delusional and then get better. It
Yes.
depends on the nature of the illness and whether or not it changes. And if it changes, then
Yeah.
and they are able to understand the legal nature and effect of appointing attorneys and what that means, then that might change and they might be able to then.
Yeah. Now, Amber, I do recommend again the article on Compass having capacity. It's very helpful and gives you a lot of different scenarios around capacity. And so that can be found on compass.info. Now, Amber asks if an EPO, if an enduring power of attorney has 3 adult children as the attorneys on it, and it states very clearly that there must be unanimous agreement, and they can't reach an agreement, I think
Mhm.
is the thrust of this question.
Yeah,
What happens then?
they
Does
can
does the
take it to one
tribunal
of them
get
can
involved?
take it to the tribunal for a
Right.
direction.
Yeah.
And there's provision in the legislation that allows the tribunal to make a direction
Yep.
in the circumstances that have been described.
Great, great. Thank
Yeah.
you. Now, in the guide, you decide who decides. There's a nice little handy list on what makes for a good attorney. Obviously, trust is right up there, but also things like, often people appoint their adult children and they may live in other parts of the world. That's perfectly fine and can work quite well for a lot of people, but it also can be quite convenient to have the person live close to you. It is, I guess, just something to consider. There are lots of other little recommendations in the guide. You highlighted some things to think about, which is if the person themselves has financial difficulties or they may have a problem such as gambling addiction, then there might be some characteristics that might make people not suitable to being an attorney, and the guide also goes into those as well.
Yeah, I think, oh, sorry, I was just going to interrupt you, Brett, there,
Yeah.
because I think that's a really important point. And I think another really important point is, and I've seen this when I was practicing as a lawyer and advise people, that there might be pressure to appoint all your children or certain people because you don't want to upset the other family member. And I think it's really important, if you can, to think about the impact of what that will look like for you, with regard to the suitability of each attorney. Because even if you don't want to hurt all your children, if you want to appoint them together, there may be one that may not be suitable,
Yeah.
for some of the reasons you've described. And there is help for people in the ACT to
Yeah.
navigate those conversations at the time before they appoint people. We've got an excellent advocacy service here called ADACAS. Relationships Australia does a lot of mediation work. The Human Rights Commission can get involved if there's concerns about abuse, neglect, or exploitation. So I think it's really important that legal, if they can get advice and support in particular with having those difficult conversations, because it's really, really important to, I think it's really important to have the conversation at that time instead of waiting for something to happen and then a whole lot of tensions may ensue afterwards.
Yeah. Very helpful. Now, you'll find all of those organizations that Liz mentioned on the Compass website in our service directory, and you can filter by powers of attorney, and they will come up. And by all means, make the most of those services. We've got a question here from B. I have a client who lived in Queanbeyan until last year and had an enduring power of attorney signed in New South Wales.
Mm-hmm.
Does the client need to have a new EPOA in the ACT, even if they don't want to change their attorney? So it's a good question. People
Mm-hmm.
in the ACT may have created their enduring power of attorney, have it all signed in New South Wales or Queensland, and then move to the ACT. Do you need to do it all again, or does it
No, we've got
hold
mutual
up?
recognition,
Yeah.
laws here, Brett. So as long as they met the requirements in their jurisdiction when they made the attorney, and as long as the powers that are in the attorney are consistent with what can be in a document here, then there's no need to do a new one. I mean, it might be if they move here permanently and they're here for 10 years or something like that, or less, they might want to redo one here because it might just be easy for banking purposes or whatever, but there's no requirement that they do. It will be recognised here.
Yeah. Catherine has asked quite a detailed question, and I just wanted to highlight it. If you do have a situation, Catherine's outlining a situation where a bank policy has now frustrated her ability to transact on her father's account. She's an attorney. Now, if the dispute would need to be resolved through a third party. And I'm imagining some of the services that we've mentioned here today. There is also the Australian Banking Association. There's also AFCA, the Australian Financial Complaints Authority, which is on Compass. So I would recommend, Catherine, going to Compass, looking at financial matters in the service directory and filtering it, and you will find some very helpful services available. Otherwise, it's very difficult for us to answer specific personal cases, but they should be able
There's,
to definitely provide you with some answers.
yeah.
Now, Liz, I wanted to ask you, it's a question that we often get. people want to make an enduring power of attorney, but there's no one that they trust to do the right thing. They've got questions or queries or reservations around trust.
Mm.
Would you recommend they make an enduring power of attorney with someone they don't trust? Or
No, I
yeah,
wouldn't.
yeah,
There's the ability to appoint trustee companies for
uh-huh,
financial attorneys. So you can appoint PTG here in the ACT, the Public
yeah,
Trustee and Guardian, or another trustee company. But it comes at a cost, so they will charge for their services. But
yeah.
if you don't trust anyone, I would not be recommending
No,
appointing
it's a
someone
powerful
you don't
document, and
trust.
you really trust.
100%.
Yeah,
And I'm kind of a bit skewed in this view because I work at the pointy end of abuse matters, and I have done for a long time. So I've seen many situations where there's been a appointment of an attorney and they've breached their obligations,
yeah,
and they could have stolen money. They could be acting in a manner that's not reflecting the person's wishes.
yeah,
They might be, they might have had a wish to be supported to live at home, and they're being moved against their will into an aged care facility without proper supports in place being trial first. So I think you really need to be able to trust the person that you're giving
yeah,
immense power to. I mean, you're basically giving them the power to make decisions for you
yeah.
if you can't make those decisions. So you wouldn't want to appoint someone that you don't trust,
Good
in my opinion.
advice. Good advice. Now, just focusing on attorneys, it's one of those things. Obviously, the person, ideally agrees to be your attorney, but it doesn't necessarily come with any training. Now, there are guidebooks and helpful resources available. I will give another plug to Compass, but on compass.info in the Enduring Powers of Attorney section, we've actually just published a story called How to Be a Good Attorney. And so there's also an article on how to choose an attorney. So I would recommend everybody have a read of those. It's also a great idea to share. I've shared some of these articles with my attorneys to say, hey, this is how you're meant to behave. You're meant to keep receipts separate. You can't mix money. Just very practical things. Are there any other resources in the ACT that are really helpful for attorneys to work out how they should behave?
Yeah. So in the ACT, we've got the Public Trustee and Guardians document, The Power to Choose, which sets out information about making an enduring power of attorney, roles and responsibilities of attorneys. The Law Society in the ACT, the Elder Law and Succession Law Committee, also developed a really good guide for attorneys' obligations, which I think is available on the website.
Mhm.
And there's information that the ACAT produces on guardians and financial managers, and I think as well attorneys and their obligations.
Right.
So they're just a few things. There's also a network of community groups here in the ACT that meet regularly as part of an elder abuse prevention network. And PTG in particular has developed a guide for guardians, which is we're looking at adjusting and distributing as well to the community.
Yeah, that's very
I think
helpful.
you can also call the public trustee and guardian for information and advice if they need
Right.
to. But I think, Brett, you raise another really important question and issue around the role and responsibility and obligations of attorneys. And this is something we see often. So there's the clear-cut ones, like don't enter into conflict transactions. One of the first matters I saw was an attorney that decided to, after their aunt had lost the ability to make decisions about their finances, thought it was okay to withdraw $80,000 and buy their child a boat. So you can't do stuff like that. You can't gift unless there's provision for it in the document. You can't enter into conflict transactions. You can't mix money, and you need to keep, as you said, accounts and receipts for spendings that could be justified if questioned.
Yeah. No, I heard an example, a case study recently of someone who bought themselves a car.
Yeah.
And the rationale they gave was, well, they had to take the principal to a doctor's appointment on a weekly basis.
Mm,
I don't think that is good justification for,
mm.
so yes, you have to be very, very careful. Now, if people do want to put in place oversight measures, one of the things that the You Decide Who Decide guide suggests is it is possible for you to appoint an attorney, an accountant to do an annual audit. So there are things that you can do in addition to the limitations. You could have an accountant look at the accounts on an annual basis, but there would be an additional fee
There'll
associated
be an
with that.
additional fee.
Yeah, yeah,
And also, if anyone has concerns about an attorney and the principal's lost decision-making ability, the tribunal has the power to review those documents. And
yeah,
I think also the power to suspend an enduring power of attorney and appoint the public trustee and guardian for a while to investigate.
yeah,
And they could also ask, I think, the public advocate or the public trustee to investigate matters if there are concerns.
yeah.
The Human Rights Commission can also take complaints about these matters.
Great. So there are options available. Now,
Options,
I wanted
definitely.
to pivot and talk to you a little bit about the importance of supported decision making.
Yeah, I'm
Um,
glad we're getting there. Yes,
yeah,
I think
yeah.
it's fundamental.
It's really important, and obviously, increasingly now, it's it's in law that you have to, you're not. These documents, such as the enduring power of attorney, isn't giving somebody the substitution power to make decisions, but rather
Mm.
they need to be supporting you in making decisions. Can you talk a little bit about the principles of the supported decision making and how they apply in the ACT?
Yeah. Look, I think this is a fundamental point, Brett, and there's certainly a move towards, certainly, even if it's not enshrined in legislation, a move as a practice towards supported decision making. So a recognition that every person has the ability to participate and make decisions in relation to decisions that affect them, and that even if they have a disability, they have to be able to have access to that path, that ability to understand and be provided information, and participate in the decision that relates to them.
Mm,
There are, I think, even though it's kind of built in a way,
mhm.
in both the guardianship legislation and in the powers of attorney legislation, in that it requires an attorney to seek the views and wishes of the principal and to give effect to their wishes as much as possible. In certain legislation, it says unless it significantly adversely affects their interests. That's in the
Mm,
guardianship context.
yeah,
And in the power of attorney, it's a similar thing, that you really need to consult at every step along the way the will, the preference of that person, to ascertain what they want and what option, provide them with information and options and help them through the use of tools, communication tools, if necessary. Like when I go out to see people, we'll take an interpreter if they don't speak the language, if they've got a hearing impairment. We will take a hearing amplifier. We've tapped into the services of OTs and speech pathologists to help with communication. When people say you can't meet with my mum, or she can't inform you of her wishes because she has dementia, we say that's actually not an impediment, that person ought to and has the right to be able to give their views and understand to the best extent possible what's happening to them and
yeah,
explain what they would like. So to support that in every way. And there are services that can in particular be drawn on to do that. Atticus, as I mentioned, has the supported decision-making team. And I know that the public trustee guardians, if they're appointed, work within that framework. But it's really important. And what I see, and I've seen so often, is that this assertion by attorneys that because the principal no longer has decision-making ability, in fact, I've seen it quite often when the principal does have decision-making ability, that they're the attorney now and they can decide who the principal can see and can't see, what relationships they have, restrict access to critical family members because of existing familial disputes, make decisions about a person going into aged care when options about supporting them at home may not have been properly canvassed or fully canvassed. So it's always, I think, if you start from the point that who's impacted most by the decision, it's the principal. What steps have been taken to understand what they want and help them understand their options and the information? That, I think, should always be the starting point with every decision. And that's certainly what we do at the Commission.
And there are lots of resources, as Liz mentioned. Atticus can support with supported decision making. Compass has actually 2 very interesting and comprehensive articles on supported decision making, the principles that underpin it, how you go about it in practical terms. And we've actually just released a story called Misconceptions about Dementia and decision making, which I highly recommend, because yes, people with a cognitive impairment can still often make lots of decisions. They might just need varying levels of support in which to do those, and to make those decisions. So very helpful resources. We'll also include this in the email that we send out to everybody tomorrow, which will have a recording of our conversation and also a transcript of all the questions that have been asked today. Now, I wanted to ask you in the last sort of 10 minutes that we're together, a few other questions. I guess one of the things that you've alluded to is the misuse and abuse of enduring powers of attorney. What are some of the common scenarios that people, can find themselves facing if misuse and abuse has been, a part of their behaviour of attorneys? What are sort of some common scenarios, I guess? You mentioned a few examples.
Yeah, there's before I get to that, I'd like to flag that there are, in the ACT, I think we're the only jurisdiction as well that has an elder abuse offence or an offence of abuse of a vulnerable adult. So if it's straight out theft, or if it's clear that there's been misappropriation of funds, the one option is a police report. And I'm aware of a couple of matters where the ACT Policing and AFP have sought to charge attorneys for significant, misappropriation of funds. I was aware of one where someone was appointed as an attorney of a person, and I think we're talking about a few $100,000 was siphoned off. So you've got the scenarios of straight out theft, right? So where an attorney just dips into the bank account of the principal to buy themselves a car or a kid boat. It could be not as obvious, but they could just take $50 out here and there. We've conciliated quite a few of those matters where the principal has wanted to maintain that relationship, but wanted some kind of repayment arrangement. So there's that scenario. There's one option of going down the policing pathway. The tribunal is, and we're another option in terms of conciliation, certainly, or even investigation. And and I'm really happy that this reform came about, but a few years ago now we pushed for the ACT Civil and Administrative Tribunal to have powers to order compensation in the event that it was found out that an attorney, or they decided that an attorney had breached their obligations. So they could order the attorney to repay back the funds into the principal's estate, and they could also ask for an account of profits. So they've got some powers that can seek to recover funds for a person instead of having to go to the Supreme Court, which is incredibly prohibitive for people to initiate that action.
Yeah. Now, there are a few terms I'm just going to, throw at you because they do get talked about. One of them is inheritance impatience, also known as theft, I guess. But it is something that people, I guess, it's a term that is becoming more familiar to people. And one of the things I guess that is, potentially alarming or sobering is that, recent research in Australia has indicated that 1 in 6 older people in the community experience abuse on an annual basis. And that psychological and financial abuse are two of the most prevalent. And that adult children can be some of the perpetrators, most common perpetrators of this. So this concept of inheritance impatience, have you encountered it in any of the cases that you've had to deal with?
Yeah, all the time.
Yep.
I've been practicing. So before my job here at the Commission, I worked at Legal Aid in the ACT. And before that, Seniors Rights Victoria for many, many years as a lawyer there. And we saw it regularly, sadly. And often you'd find that financial and abuse and psychological abuse go hand in hand. And it's that the paternal, the kind of maternal, paternal love of the child that impedes them from necessarily taking adverse action because they don't want their adult child to get into trouble. But what ends up happening is that they might be left with no home and have their pension cut, and it could be easily mitigated by getting support and legal advice. So I would strongly encourage people to get legal advice if they can afford it in making an enduring power of attorney, but also if they want to dispose of an asset. There are services in the ACT that can help people get assistance at a discounted rate. It would be good to contact the Law Society. There's also the Public Trustee and Guardian and Older Persons Legal Service at Legal Aid.
Yeah, thank you, Liz. That's very helpful. Now, I will mention that on Compass, we have a service directory. If anybody is experiencing abuse, there are services available and you can filter them by the ACT. There's also a filter for elder abuse specialists. And there's also the National Elder Abuse Helpline, which is 1-800-353-374. Another term that I wanted to mention to you is one that's probably more insidious and difficult to identify, and that's inheritance maintenance, where adult children are essentially trying to maintain the wealth of their inheritance or the money that's coming to them. And so not spending the adequate amounts of money on caring for their adult parents who, that they are the attorneys for. I guess that could manifest in many ways, one of them being neglect. Is that something that you have encountered as well? And what forms can that take?
Yeah, sadly, yes.
Yeah.
It could take the form of neglect. It could take the form of, trying to hold out if a parent wants to go into aged care, but they're also living with the parent. Not consenting to them going into aged care alternative accommodation. We've got a few of those on foot at the moment. It can take the form of just financial abuse in terms of restricting and control. So restricting the parent from spending money, not spending essentials on the parent, not wanting to get services in for the parent because it costs too much money that they might need to top up. We've seen it all, sadly, Brett. And there are services that can support people in these situations. Advocacy support, all these matters can come to us where we would get involved. And, legal options as well are available for people, the police if necessary. And we often will work closely with these agencies and go and see the person. So we'll go to their home, get a sense of what's happening, hear from them personally, always as a starting point to get a sense of what they want to do and what the issues of concern are for them, and take it from there. But yes, sadly, it's a common scenario.
Now, we're obviously talking about this because it is a reality. It's not necessarily to say there are risks, obviously, with having an enduring power of attorney. But on balance, it's a really powerful and very practical document. Talking about some of these issues is one of the missions of Compass. And so you will find information on understanding elder abuse in all its forms and what you can do to respond and prevent it, or reduce the risk of it occurring in your lives. So lots of resources there. We've only got a few minutes left. This has been a terrific conversation. Thank you very much, everybody,
Thanks, Brett,
for all of your questions. If anybody has a final question, please pop it into the chat, because we're soon going to be wrapping up today's chat about enduring powers of attorney. As I mentioned, the video will be sent to you tomorrow. I've really only got one final question to put to you, and you have referred to the concept of conflicts of interest. But I thought it might be helpful just to articulate some common conflicts of interest, because you don't want to be appointing an attorney that has an obvious conflict of interest. But what are some of the common ones that people should be avoiding or being aware of?
Oh, look, I think it's just where if you have as an attorney have an interest in something and you're taking financial advantage or dipping into the funds of the principal to benefit yourself financially, in this context, if we're talking about finances, there's a conflict there, right? So, even if you're saying, unless it's provided for in the document, and the principal can say, I consent to my attorney entering into this transaction where it's a conflict, like they might get paid to do certain things or to drive them around. Unless it's specified in the document, can't really do it. If the tribunal gives a direction, then you're covered, but otherwise it's just a rule in the legislation that you don't,
because it's an unpaid job being an attorney, I guess, unless it's explicitly written into the enduring powers of attorney. So yes, you have to be above board and treat it as such. So I think we might wrap up today's conversation there. Liz, thank you so much for your time.
Thanks, Brett. And I hope I haven't been a negative Nelly. Like I think because I've worked at the pointy end for so long where things have gone wrong, that I've got a distorted view of it. But ultimately, they can be a really can be a really positive tool to have control of your life in the future if you aren't able to make decisions. But it's fundamental that I think you consider you get advice, and you also appoint people that you trust and are going to include you along the way and respect your choices.
Yeah. Thank you. Wonderful note to finish up on.
Thanks.
So we'll be sending out an email to you all tomorrow, just to let you know that compass.info is a project of Elder Abuse Action Australia. You can find out all about them on our website, along with lots of information about enduring powers of attorney, enduring guardians, and lots of other helpful information. So thank you all very much for being here with us today. And as I mentioned, if anybody is experiencing abuse, we have elder abuse specialists in the service directory. And I'll just say that number one more time: the National Elder Abuse Helpline, 1800 353 374. Thank you all for joining us today and enjoy the rest of your afternoon.